Hello and welcome to episode 5 of Counting on Law. Earlier this year, the Supreme Court took note that there are 8 lakh or more execution petitions languishing in courts across the country. The court has in the past specified that these cases must be disposed of within 6 months. The apex court hasn't been kind to such delays. They've called these cases, which are disguised appeals, frivolous, vexatious, and cantankerous. But descriptive adjectives hardly help in solving systemic issues. What are these execution applications? What story can the data tell us? And what more can we learn from them? And how can we perhaps tweak the system to do better with respect to executions? We look at the Bombay High Court's original site, data from 2017 to 2024, to try and find out some answers. Let us imagine a criminal case and a civil case that starts at the same time. Both go through rounds of evidence and hearings and arguments and end in judgments. In the criminal case, at the point of the judgment, a sentence is pronounced, which is the operative part of the criminal judgment. As soon as the sentence is pronounced, the convict is grabbed and thrown into the dungeons, if so be the sentence. In contrast, in the civil case, as soon as the decree is pronounced, which is an equivalent to the sentence, the court takes a hands-off approach and assumes that the judgment debtor, against whom the decree was passed, will obediently comply with the decree, and the decree holder, who deserves the fruits of the decree, will be made good by the judgment debtor. If, however, in the off chance the judgment debtor does not comply, then the decree holder has an option of going to court and asking the court to enforce the relief on their behalf. This is mechanized through what is known as an execution application or an execution petition. We examined 19,779 execution applications filed in the Bombay High Court between the 1st of January 2017 and the 31st of December 2024 to understand these execution applications in greater depth. Around 43% of these execution applications, that's 8,460 of them, were disposed by the court, and the remaining were pending after the time period of our study. Within these 43% of execution applications that were disposed, the aggregates were as follows. These take about 650 days median time to disposing, meaning half of these cases take up to 650 days and half take 650 days or more to get disposed. But the variance in this data set was very high. Some cases took just 5 or 50 days to disposal, while some took more than 2,857 days to disposal. Now, this spread was startling, and we had to understand why some cases were disposed of sooner and some took longer. And for this, we looked deeper into this data. Disposals can be of many types. Take the example of execution applications itself. The court may, on seeing a case, realize that this case was already adjudged on merits by another court, and its role is limited to enforcing the judgment. Here, the court takes the case and deems it allowed. This is deemed as the allowed disposal type. Sometimes the court may see that there may be infirmities in filings which aren't rectified, or certain legal defects with the filings that were made. The court may dismiss this case. There are situations where both parties come up to the court and say, "We have settled the matter outside the court and these are our consent terms." The court deems this disposal as settled. The party filing the petition may sometimes tell the court that it wishes to withdraw the matter. We deem this as withdrawn. There is also a small proportion of cases where the court feels that there is an alternative court that's more competent to execute the particular case, and this is transferred to that court. This disposal type is deemed as transferred. Now, we took the set of 8,460 disposed cases that we were studying and classified them on the basis of these disposal types. Now, we must admit that our legal biases on the basis of our legal theory training was that most of these cases would be allowed. Since another court had already adjudged this matter with finality, the executing court is not supposed to sit on appeal and is simply supposed to enforce and realize that decree for the decree holder. The truth, however, was different. The data spelled otherwise. Only 43 out of these 8,460 cases were indeed allowed. This was a 0.5% of the total share of disposals. The remaining 99% were either dismissed, 66%, or withdrawn or settled. Now, this was very confusing. This went against every fiber of our legal presumptions, and we reached out to practitioners to make sense of this data. They told us that after acquiring a decree in favor of their client, almost always as a default step, as soon as the appeal window was over, they would file an execution petition in the court. Most often, they do not even follow up on this execution application as they assume that the parties will settle the matter outside the court. And this seems to be the case in most of the situations. But why did most of these parties have to go and file execution applications to begin with? Why weren't these settled sooner? How long do these cases actually take to settlement if that's the case? There are two possible interpretations or stories that arise from this set of data and inferences. One, the optimistic story, is that these 43 cases that were allowed are really the worst apples of the lot. These were the toughest cases for which the court had to really sit through these cases and acquire the relief for the decree holder, taking about median 381 days. The remaining cases actually see settlement or withdrawal outside, and the lawyers and parties have no incentive to go and close off the case. The picture doesn't seem as grim as it sounds when we listen to the anecdotal accounts. However, on the other hand, there is an alternative and more plausible interpretation in our opinion, one that aligns with the nightmares of execution that we have heard all the way from the 1872 Privy Council cases. It is that these 43 cases were actually those lucky cases which really saw the fruits of execution. In the remaining cases, both the decree holder and the judgment debtor, knowing far too well that the system takes too long, does not use the help of the court. The decree holder takes a significant haircut and compromises for an amount far lesser than what they truly deserve. We believe there are a few compelling reasons as to why this might be the case. First, there are binding judgments of the Supreme Court that mandate that if executing courts do not dispose the case within 6 months, they have to give written orders explaining reasons for not doing so. Most of these cases have had their first hearings only after 1 to 2 years from filing. If courts were indeed scrupulous in their following up on execution petitions, this wouldn't be the case. Second, recent scholarship has shown that the CPC's interest rate ceilings actively incentivizes non-performance of judgment debtors. Section 34 of the CPC caps interest rates at 6% simple interest. This is far lower than what the market would appreciate on that amount if put elsewhere. Therefore, every day delayed is money gained by the judgment debtor, and every day delayed is money lost by the decree holder. The decree holder is far better off taking a haircut and settling for a lesser amount than waiting for the judgment debtor to ultimately pay up the whole amount, or perhaps waiting for the court apparatus to catch the judgment debtor and allow realization of the money. Now, apart from these two stories of how incentives are misaligned, judges and lawyers also do not have fair incentives to see execution to completion. Let's take the case of judges. Judges are rewarded for heavier case disposals and faster timelines of disposals. A judge who disposes a civil suit and its execution as two separate suits, which are, say, for example, of 2 years each, ends up disposing double the number of cases at half the time than a meticulous judge who sees through the entire civil dispute and its execution for a 4 years timeline. This was pointed out in 2009 in a Supreme Court judgment where the court wondered why we treat a civil suit and its execution as two divorced entities. It suggested that the Law Commission and the Parliament re-examine this issue and merge these two entities together. Neither the Parliament nor the Law Commission have paid heed. Let's take the case for lawyers. Indian lawyers are prohibited from charging contingency or success fees on what they fetch for their clients. Senior practitioners that we spoke to scoffed at us when we asked if they take up execution petitions. They said that only juniors or people without cases pursue execution applications. This is because there is far too little money available in these execution petitions, and they don't earn anything by pursuing these execution petitions mindlessly. What is the harm in allowing lawyers to take a cut from what they acquire for their litigants and their clients if it ends up making the litigants better off? What is so dishonorable or ignoble about taking a part from what you earn? The present system is a mindless mimicry of the 19th century civil litigation architecture. This was copy-pasted into Indian law without any forethought. The UK, from where it was copied, has moved far ahead in the past decades. Today, they have a competitive industry of execution professionals who pursue these cases after the decree dates. Litigants approach these execution professionals and seek their support, and these execution professionals compete between each other on the basis of faster enforcement timelines and greater efficiency. We are still stuck with this 19th century architecture that was not designed by us or designed for us. We believe that it is better to be safe than to be sorry. Instead of believing in the most optimistic scenario and letting the system be, it is better to get back to the drawing board and reimagine the civil litigation landscape on the basis of pure common sense, realigning incentives and interests of all parties together. Thank you.